as for Baez asking the judge, if you don't think there's enough evidence at this point to throw them off the case, then you really should bring them into court, put them on the witness stand, make them answer questions under oath. What's your reaction to him asking the judge to do that?
That's never going to happen. The state attorney's office will object. There have been cases before with much more solid grounds to perhaps place a prosecutor on the stand and cross-examine them or examine them as to alleged misconduct, and the courts have uniformly held, no, we're not going to place the prosecutors on trial in these cases.
And as far as his accusations that, he says he called the Florida bar complaint an attempt, quote, an attempt to have the attorney for the defendant tainted by an investigation. What's your response to that?
Every lawyer has an obligation that if there is misconduct that they become aware of, that they report that to the bar. In this instance, some of these statements that were attributed to Todd Black, who we thought was an employee of Mr. Baez, were outrageous, they were defamatory, and they certainly had, if they had been made by a lawyer or a lawyer's employee, would have given rise to some bar sanction. So in this particular case, not only did the state attorney's office have a right to bring this to the bar's attention and ask the bar to determine whether or not these statements violated the rules of ethics, they had a duty. And this court's going to find that the state attorney's office had that duty, and this court is not going to remove an assistant state attorney from this case, nor is he going to recuse the entire state attorney's office. The bottom line is that
he's doing stuff he's not supposed to be doing, then he doesn't.
You engage in unethical behavior, and you get called on it. You can't then hide behind the Sixth Amendment and say, "Well, you're trying to interfere with adequate representation for the client." Right. That's just ridiculous. This is just reducing the judicial proceedings to two kids in the playground, and one kid is upset now, and so he's filing a motion to get back at the other kid who he perceives did something wrong. It's just schoolyard antics. This is nothing.
Well, I'll ask you. Do you look at this as tit for tat, that there was a bar complaint made against him, he's not happy about it, so he's...
The defense has reduced this to a schoolyard fight, and it's though the one school kid is angry at the other school kid for something he did, and so he's going to now file this motion and say, well, you bruised my feelings and you've also attempted to interfere with my relationship with the client. It is almost ridiculous and really has no place in these proceedings at this point in time.
Is it, you reduced it to sort of like a school playground battle or something?
Yeah, it's just a school, like two school children out in the playground having a fight with one another, a tit for tat. And this in no way rises to the level of interference with the Sixth Amendment right to counsel on behalf of Casey Anthony.